Good evening, everyone. I, Sakib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be an absolute pleasure on our part to be able to listen to Professor Philippe Sands, QC, who has very kindly made the time to talk on the East-West Street, the ICJ, Genocide and the Rohingya. Before we request Professor Sands to start, I would like to bring to your notice to notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you here. Now, regarding our guest speaker, Professor Sands is a scholar who needs no introduction. He's a British and French lawyer and professor of laws and director of the Center on International Courts and Tribunals at University College London. He appears as counsel and advocate before many international courts and tribunals, including the International Court of Justice, the International Tribunal for the Law of the Seas, the European Court of Justice, the European Court of Human Rights, and the International Criminal Court. Professor Sands serves on the panel of arbitrators at the International Center for the Settlement of Investment Disputes and the Court of Arbitration for Sports. He is also the author of 17 books on international law. Now, before we start listening to Professor Sands, I would like to request Professor Rizwanul, Chair of the Department of Law at North-South University, for his introductory remarks. Sir, please.
Thank you, Sakib. Good morning or good evening, dear respected listeners, depending on wherever you maybe are. It's my utmost pleasure and privilege to say a few words on Professor Sands' talk today. Genocide, the crime of crimes, a horrible crime targeting to destroy a particular group of people, a horrific crime that evokes many emotions among many. Who better to speak on this than Professor Philippe Sands QC, who I think fulfills all the eligibility criteria or the desired list that you would get from a legal academic practitioner. More importantly to me, his legal works on genocide is not just a legal work. His work transcends boundaries. He brings in his personal experience and he makes it something of a universal value. He, through his groundbreaking works, I should rather say, he writes on genocide in ways that just not becomes something mere academic, but becomes a work which, in my view, is non-fictional, but literary work. And if I talk to the listeners in our part of the world, particularly to my esteemed audience from Bangladesh, genocide brings to us, many of us, the horrific memories of the atrocities of 1971, the horrible crimes that were perpetrated on our forefathers in this country in 1971. And also what happened in the Rakhine province of Myanmar in last couple of years, what happened to the Rohingyas, that is not just a thing which should shake the conscience of ours in its own right, but for many Bangladeshis, this is something that is a living reality. The influx of Rohingyas, the atrocities perpetrated on them, which has forced them to flee for their bare human existence and that have brought them to Bangladesh, that is a living reality for many people in some parts of Bangladesh. So with all these keeping in mind, I look forward to the talk that Professor Sands has very generously agreed to give for us tonight. And I'm sure it would be a very riveting talk. I look forward to this. Thank you all once again for your time and company.
Thank you so much, Dr. Rahman and Professor Islam. I'm so very thrilled to be speaking with all the participants from wonderful North-South University. Bangladesh is a special country for me. As you may know, I've visited many times. I have many very good friends in Bangladesh. I've had doctoral students. And of course, I had the great privilege of being one of the counsel for Bangladesh in the law of the sea disputes with Myanmar and with India some years ago, which I think were reasonably successful for Bangladesh in relation to the delimitation of the Bay of Bengal. And so when I received the invitation, I had no hesitation in accepting. It's a very great pleasure to be with you, and I hope one day soon it will be in person. The request was that I talk about the case at the International Court of Justice, and I'm very happy to do that. I want to set it in its broader context, though, and talk a little bit more about how we got there. I want to treat this as being under what in London we call the Chatham House rule. This is an academic conversation. It would be best if people don't tweet and Facebook anything that I say, and then I can talk much more openly. That's how I do it at my own university, but it enables us to have a nice and frank conversation. So some of you will know that in December 2019, there was a remarkable hearing at the International Court of Justice in The Hague, a place where I've been privileged to argue quite a lot. I should just say I plan to speak maybe for about 30 minutes, and then I'd like to throw it open to questions, because you will have the things that are of particular interest to you, and I'm very keen to be responsive to the things that you want to talk about and ask about, and I'll do my best to answer those questions. So don't worry if I don't talk about them or raise them in my comments. Feel free to ask anything you want as we proceed. So December 2019, a remarkable hearing took place in the case brought by the Gambia against Myanmar, alleging that a community that is called the Rohingya community, Muslim community in Myanmar, had been subjected to treatment which amounted to genocide within the meaning of the 1948 Convention on the Prevention and Punishment of Genocide. The case had been filed a few weeks earlier by the Gambia, which is a relatively small African country. And you may ask yourself the question, how could it be that the Gambia, also an Islamic country, would wish to bring a case against another country for things taking place thousands of miles away? This is the first time this has ever happened. It was a unique situation. The other genocide cases before the International Court, Bosnia against Serbia and Croatia against Serbia, if you like, Bosnia and Croatia were bringing cases to protect their own people, their own community, against acts alleged to be genocide. So this was a unique case. How did it get to the court? Well, Bangladesh plays an extraordinarily important role in this matter, as you all know very well. There are hundreds of thousands, if not more, refugees from Myanmar, members of the Rohingya community, who have fled across the border to safety. Many of them are in camps at Cox's Bazar. I've actually been to Cox's Bazar back in the early 2012, 2013, when I was involved in the cases on the delimitation of the Bay of Bengal. So I at least can say I know it a little bit. There was a visit in 2018 organized by the Organization of Islamic States to Cox's Bazar. And amongst the delegates from the Organization of Islamic States was the Attorney General and Minister of Justice of the Gambia, a man called Ba Tambadou, a very fine lawyer. Actually, he had been a student of mine many years ago at the School of Oriental and African Studies in London. he then went on to work as a prosecutor at the International Criminal Tribunal for Rwanda, based in Arusha. And as he described to me, when he went to Cox's Bazar and into the camps in which the Rohingya community were staying, he talked with people. And as he described it, he said, having been involved in the genocide in Rwanda, the stories that people were telling me, I recognized immediately for what they were, that they were describing a genocide. He went back to his country, Banjul in Gambia, and persuaded his government to bring a case with the support of the Organization of Islamic States. And that case was filed in November 2019. It alleged that Myanmar was engaged in a genocide against the Rohingya community and sought at the same time provisional measures to prevent further acts of atrocity pending the resolution of the case. The basis of the case was the 1948 Convention on the Prevention and Punishment of Genocide. And it was the third case brought at the International Court. Now, let me give you a little bit of background before I say what happened in the hearing and what will happen going forward, so that you are aware of that. Professor Islam very kindly referenced some of my other activities, and I'm going to refer in particular to one book that I published 4 years ago, and I'd be very pleased to send a couple of copies to you, Professor Islam, for your students to read in the library, because it's probably not easily available. This is the book. It is called East-West Street, and how wonderful that I'm talking about East-West Street at the North-South University. I do rather like that. And it's a book that has as its subtitle, as you can see on the inside, on the origins of genocide and crimes against humanity. And it's a book about 4 men. One is my grandfather, Leon Buchholz, who was from the city of Lemberg in the Austro-Hungarian Empire, and whose family was exterminated between 1939 and 1945 in the genocide that took place against Jewish and Polish members of the community of that region. And I received an invitation to give a lecture in that University of Lviv in 2010 on the cases that I've done on genocide and crimes against humanity. And I accepted the invitation because I wanted to find the house where my grandfather was born, in that city of Lviv. Lviv and Lemberg is the same city. And so I went to Lviv in October 2010 with my mother, my aunt, and my son. It was the first time any member of my family had been to the city since 1923, so it was quite exciting. And we found the house where my grandfather was born in 1904, and that was very exciting too. But I discovered other things that were sort of amazing. Firstly, I discovered that the man who invented the concept of crimes against humanity, which was put into the Nuremberg Statute in 1945, Hirsch Lauterpacht, possibly the greatest international lawyer of the 20th century, amazingly, he came from that region and he studied at the law faculty that had invited me, Lviv. But the people at the law faculty did not know that. And then I discovered that the man who invented the concept of genocide, Raphael Lemkin, also came from that region and also studied at the same law school, although not at the same time. Lauterpacht was at Lviv University Law Faculty from 1915 to 1919, and Lemkin was there from 1921 to 1926. And I started writing a book about the 3 men. Leon, my grandfather, Lauterpacht, inventor of crimes against humanity, and Lemkin, inventor of the concept of genocide. And then into the story came a 4th man, Hans Frank. Hans Frank was a German lawyer, distinguished, famous. He had been Adolf Hitler's lawyer from 1928 to 1933. And in 1939, he was appointed Governor General of Nazi-occupied Poland. And in the context of his activities there from 1939 to 1945, he oversaw the implementation of what was called the final solution, the extermination of millions of Jews and also 1 million Poles. And for that, when he was caught in May 1945, he was sent for trial in the famous Nuremberg trial opened in November 1945. And what was so remarkable about what I discovered was that amongst the prosecution teams, on the British team was Hersch Lauterpacht, and on the American team was Raphael Lemkin. Lauterpacht prosecuted Frank for crimes against humanity. Lemkin prosecuted Frank for the crime of genocide. And what was so striking and remarkable was that when the trial started, neither men knew that Hans Frank was responsible for the murder of their entire families, their parents, their brothers, their sisters, their siblings. You know the meaning of genocide in Bangladesh, so I don't have to explain to you what the consequences of killings on this scale mean. You understand it very well. And so the book that I wrote, East-West Street, tells that story. Raphael Lemkin invented the term genocide in 1944, in November. And while I was doing the research, I found the piece of paper which set out his thinking about it. And I'm just going to put that on the screen now. This is a paper I found at the University of Columbia, Columbia Law School, 6 years ago. And you can see on the text, he writes the word genocide here on the left-hand side, and you see him writing the words extermination. So this is his own handwriting. It's probably written in 1944. He's written the word genocide on this piece of paper 25 times, and sometimes he's crossed it out and written other words for the invention of the word. But what Lemkin was concerned with in terms of the concept of genocide was the destruction of groups, the killing of human beings, not because of what they had done or their individual activities, but because they happened to be a member of a group, that they happened to be a member of a religious group, an ethnic group, a national group. Lemkin also would have included a cultural group. The trial proceeded, and Hans Frank was convicted for crimes against humanity, but the judgment at Nuremberg made no reference to the term genocide. And Lemkin was bitterly disappointed. He described the judgment of October the 1st, 1946, and the failure to refer to the crime of genocide, which was in the indictment because of his efforts. He described that as the darkest day of his life, worse even than the day he learned about the deaths of his beloved parents, his mother Bella and his father Joseph. Instead of lying in a corner and weeping, Raphael Lemkin single-handedly decided to promote the idea of a convention to prevent and punish genocide. And in December 1946, he single-handedly persuaded the United Nations General Assembly meeting in Paris to agree that the world would negotiate a convention on the prevention and punishment of genocide. And he led the way for 2 years. And that convention was adopted in December 1948. And it's a very important convention for many reasons, but one of the reasons is it's the first modern human rights treaty. And it criminalizes, under international law, the intention to destroy a group in whole or in part on grounds of ethnicity, nationality, or religious affiliation. For about 50 years after the Genocide Convention was adopted, nothing much happened. And then in the early 1990s, the terrible crimes and killings took place in the former Yugoslavia and in Rwanda. And 2 international criminal tribunals were set up, one for Yugoslavia, one for Rwanda. And the Convention on the Prevention and Punishment of Genocide came alive once more. And what happened, in a nutshell, was that in 1993, the government of Bosnia brought a case to the International Court of Justice in The Hague, alleging that Serbia was responsible for committing or failing to prevent a genocide from taking place on the territory of Bosnia and Herzegovina, essentially an Orthodox Catholic community perpetrating a horror against a Muslim community. And that case, of course, you will have read about, and you will know that ultimately in 2007, the International Court of Justice found that Serbia was responsible for failing to prevent others from perpetrating a genocide, but did not hold Serbia itself responsible for perpetrating a genocide. That case was accompanied by another case brought by Croatia against Serbia for killings at Vukovar and the Krajina. I was involved as counsel for Croatia in that case, and Croatia failed in that case. They failed because they were unable to prove that there had been an intentional destruction of a group in whole or in part. And this is the essential difference between crimes against humanity and genocide. The killing of large numbers of human beings unlawfully will always be a crime against humanity. But will it be a genocide? It will only be a genocide if the prosecutors or the legal counsel can prove the intention of the killers to destroy a group in whole or in part. And this is the challenge with the crime of genocide. Most mass murderers do not leave bits of paper around saying they intend to destroy the group in whole or in part. And so you are left to infer that from a pattern of behavior. And inferring intention is a difficult thing to do. Which brings us to the events of 2016 and 2017, when, as you know, the Tatmadaw, the military, the army of the government state of Myanmar, turned on the Rohingya community. And you will know that the Rohingya community in Myanmar is not recognized as a group under the domestic law of Myanmar, and has been subject to persecutions for many decades. But in 2016, 2017, matters took a bad turn for the worst, and many thousands of people were killed, and hundreds of thousands were threatened with death. And the consequence of that was that they fled, very understandably, to a place of safety. And Bangladesh provided a place of safety. 2 years later came the famous visit by the delegation of the Organization of Islamic States to Cox's Bazar, and the case was filed. I was involved in preparing the application. The application was filed, and under the rules of the International Court of Justice, once an application is filed, you can also make an application for what are called provisional measures, interim relief, injunction, to stop the further acts of killing. And that is what happened. We argued that in the International Court of Justice, and as you know, a month later, at the end of January 2020, the International Court of Justice handed down an absolutely historic provisional measures order. Historic because it was unanimous, historic because it went far beyond what had happened in the Bosnia case. Not only did it order Myanmar to cease and desist from any act which was genocidal in character or effect, but it did 2 other things that were unique and have never happened before at the International Court of Justice. It ordered Myanmar to preserve, protect, and not destroy any evidence of wrongdoing. And even more significantly, in my view, it ordered Myanmar to report every 6 months on the steps it was taking to comply with the Provisional Measures Order. And that was a very important provision, because the last time there had been provisional measures, which was in 1993, there was no such equivalent order to report, which meant the court had no continuing role. And as many of you will know, 2 years after the Provisional Measures Order, in 1995, the terrible killings happened at Srebrenica. 8,000 Bosnian Muslim men exterminated by paramilitary groups acting on behalf of Serb communities in and around Bosnia-Herzegovina. So the Provisional Measures Order of 2020 was extremely significant. It was a great privilege and burden, I would say, to be in that case. The case was made even more interesting by the appearance at the International Court of Justice of the de facto head of Myanmar, Anseng Sushi, who had, as you know, was the daughter of the man who was the founder of the Tatmadaw. She herself, I am very sorry to say, despite having won a Nobel Prize for Human Rights, for her work on human rights, has not been decent in her treatment of the Rohingya community. I addressed that in my second round argument. I spoke to her directly and castigated her for her refusal to use the word Rohingya to describe the community. And also, and to my mind, this was deeply shocking, her refusal to even, or her failure to even express regret about the systematic acts of rape that had been perpetrated on so many young women of the Rohingya community, who are, after all, citizens, in my view, of Myanmar. And that shameful behavior she simply passed in silence. And I was very troubled by seeing her there. So the court ordered provisional measures. What happens next in the case? The Gambia then filed its memorial, and that happened last autumn. And the memorial having been filed, the next step would normally be for Myanmar to file its counter memorial. But as it was entitled to do, Myanmar filed preliminary objections to the jurisdiction of the International Court of Justice. The principal argument that Myanmar has made in that application is that the Gambia has no legal interest in protecting the rights of the Rohingya community in Myanmar because it is not directly affected by what has happened. And so the case has been paused whilst those preliminary objections are heard. The preliminary objections have been filed. The Gambia files a response. And later this year, there will be an oral hearing on whether the International Court of Justice has jurisdiction or not. It's always very hazardous to predict an outcome. I try not to do it, but I'd be very surprised if the preliminary objections are successful. And the case will, if they're not successful, then proceed to a filing by Myanmar of a counter memorial, and then a reply by the Gambia, and then a rejoinder. And I would expect we will have hearings not before early 2023. In the meantime, Myanmar has the continued obligation to report to the International Court of Justice on the steps that it is taking to avoid members of the Rohingya community who remain in Myanmar from not being subjected to acts that are genocidal in character. And the definition of genocide we can come to later on. It is not only acts of killing, but as you will know, there are other forms of discriminatory act, including acts of sexual violence and rape, which are or can be characterized as genocidal in character. So that is where we are now on the case. That gives you the outline. It is a hugely important case. before the International Court of Justice. I think it's very likely that, well, the Netherlands and Canada have announced that they are going to intervene in the case. And that's extremely important because it signals to the judges on the court that this is not just one Islamic country looking to protect the well-being of a Muslim community in Myanmar, but that it is of truly global interest. So that intervention, when it comes by Canada and the Netherlands, is very warmly recognized. I do also want to signal, because Bangladesh was present in The Hague in 2019 during the hearings in December, that Bangladesh has provided an enormously important role and assistance to the Gambia in prosecuting this case, including the provision of material and witness testimony and other evidentiary materials. And of course, it has provided assistance as we gather the witness statements of so many people who are presently now in Cox's Bazar in camps. It was extremely moving for me personally to meet members of the community, the Rohingya community, who were flown to The Hague from Cox's Bazar by the Dutch government and who were present. And we spent time, a lot of time, with members of that community. And it reminded me, of course, that from the time of my grandfather back in the 1940s, there was no International Court of Justice to do what the International Court of Justice did here. And that, of course, points to a very significant change and development in international law between the 1940s and today. Let me stop there. I've used up about 30 minutes. That gives you a bit of context. I'm very happy to try to answer as many of your questions as I possibly can. So over to you, dear friends at the North-South University.
Thank you very much, sir. It was an absolute pleasure hearing from you. We do have certain questions, and we did actually have a lot of questions beforehand, but I might as well just, I think we do have enough time, and it would be an absolute pleasure on our part, provided that you actually entertain the questions. Should I be telling you the questions, sir?
Yes. Why don't you feed through the questions, because you're best to know what are the questions that are useful from your end.
Of course, sir. So the first question, this comes from the chair of the Department of Law, Dr. Rizwanul. Would you express your views on the role of the third parties, for example, Netherlands and Canada's involvement in the ongoing Gambian case against Myanmar at the ICJ?
Sure. Well, I've said a little bit about it. They haven't yet intervened. They have indicated that they will intervene. And as you may well know, there are two bases for intervention under the statute of the International Court of Justice. On one basis, you can address the facts of what is going on. On the other basis, your role is more limited to the interpretation of the relevant instrument, the 1948 Convention on the Prevention and Punishment of Genocide. I don't know yet on which basis they will intervene, but my hunch is that they will certainly intervene to try to assist the court in interpreting and applying the convention in a modern way, consistent with the values of today rather than the values of 1948 when the convention was applied. So we are expecting that intervention. There is also a suggestion that another country would intervene, and that is the Maldives. That intervention is different, and it's, again, slightly unclear why the Maldives feels a need to intervene, because the Maldives, as you know, is a member of the Organization of Islamic States, which is already very involved in the case. So we don't quite know what is going to happen with that.
Thank you very much, sir. We do have another question. Could satellite images be used as evidences in the ICJ case?
That's another excellent question. Yes. Of course, one of the things that's very difficult to get is information on the ground. The background to these cases are premised on obtaining evidence. And I have to salute in particular here the work of the United Nations, the High Commissioner for Human Rights, the Special Rapporteur on Genocide, the Special Rapporteur who has been dealing with matters of the Rohingya, who have produced a series of remarkable reports in 2017, 2018, in which they have identified genocidal acts. And I think those of you who've watched the proceedings, incidentally, I should say, if you're interested in this, you can go on the website of the International Court of Justice and you can watch some of the arguments. You can watch Anseng Sushi's arguments. You can watch my response and the responses of the Attorney General of the Gambia. And I do think that is much better than reading it on the page. You get a feel for what is going on. So what evidence can you rely on? We can rely obviously on witness statements, and we have a large number of witness statements, and the government of Bangladesh has been offering assistance in making access to victims available. But of course, there are other forms of evidence that you can take. There are voice recordings. There are films made by reporters of what they saw when they went to some of the villages. There is photographic evidence. You will know also that there is reportedly witness testimony given by at least 2 members of the Tat Mador who have provided statements about what they were told to do. There is evidence on Facebook and on Twitter because, unbelievably, members of the senior military used social media to encourage certain forms of activity. So all of that is available. And in principle, yes, you can use satellite imagery. What would satellite imagery be used for? Well, satellite imagery could be very important, for example, in establishing the destruction of villages and communities and the cleansing, the removal, the wholesale bulldozering of entire villages. And that is in principle something that can certainly be used. It can also be used to show movements of troops across time. And I would be surprised if satellite imagery is not used in some form in the case going forward. But the details of that, of course, have to await what comes later.
Thank you very much, sir. We do have another question. Do you think that the recent military coup in Myanmar would make any changes to the plight of the Rohingyas trapped in Myanmar or the case at the ICJ?
Huh. Well, that's obviously a very timely and important question. You know, like you, I heard about the coup on the radio. I woke up one morning a few days ago and I put on the radio, and on the BBC I heard that there had been a coup and that the Tat Mador, the military, had taken over. We don't know what the implications of that are going to be for the case. We don't know what it means for Myanmar's continued participation. We don't know what it means for Myanmar's continued compliance with its reporting requirements to the court. We don't know what it means in terms of the arguments they may make. And of course, we do not know what it means for the community that is most threatened by the actions of the Tat Mador. One aspect, of course, that a lot of people are asking about is what is the role of Anseng Sushi in all of this? Now that she has been detained, some of the Western media has reacted to that with regret and almost a sentiment that she is some sort of a democratic protector who could help bring democracy to Myanmar. And here, and I speak very personally here, I have to say, having sat within 3 or 4 feet of her as she made her arguments in the court a year and 15 months ago, I cannot say that Anseng Sushi is, in my eyes, a friend or protector of the Rohingya. Her arguments were not happy arguments from my perspective. I admonished her personally for failing to use the word Rohingya. And you know, if you can't even use the word Rohingya because it's so offensive to you, you know, she refers to them as the Muslims of the North or other derogatory terms. I do not think that on the basis of what I have seen, Aung San Suu Kyi can be seen as a defender of the interests of the Rohingya. Why she went to the International Court to make those arguments, I do not know. One of the consequences of her appearance was that it greatly increased media attention on the case. There was a huge amount of media. I have to assume she went for domestic political purposes. There was an election coming up. She seems to have won that election. That is what caused the army to react as it did. But her future role in the country's affairs is uncertain, but I'm under no illusions as to her sentiments towards the Rohingya community. There are other aspects, of course, that are of great historical interest in all of this. And in a certain sense, Myanmar has also played the colonial card. And it has argued on occasion that it was the British who introduced the Rohingya community into Myanmar when it was the colonial occupier, and that somehow colonialism was to blame for what had happened. Well, that may or may not be accurate, but I think it's wholly irrelevant to the question of the responsibility of the state of Myanmar to treat the Rohingya community with respect and not to violate their rights under the Genocide Convention. So the coup has just happened. We wait to see what it will mean in practice.
Thank you very much, sir. We do have a question from Mr. Farhan Ahmed. He's a lecturer in Public International Law from Brack University. He writes, your works have highlighted a kind of an external struggle between genocide and crimes against humanity with regard their focus on the group and the individual respectively. In light of this, firstly, has crimes against humanity been relegated to the second tier of international crimes, or has genocide elevated above others?
Right.
If so, what are your views on the development, particularly this phenomenon of assessing and addressing most atrocity situations from the perspective of genocide? Secondly,
thank you. Yeah. Wonderful question.
Secondly, how would the new Crimes Against Humanity Convention affect the status quo?
Okay. So I didn't quite catch the name of who that was, actually.
Mr. Farhan Ahmed, he is a lecturer in public international law from Brack University.
Thank you, Mr. Ahmed, for that question. It's a really, as you will know from my writings, for me, it's a very important question. I described how genocide and crimes against humanity emerged at exactly the same moment. These two former students of the University of Lviv in what is now Ukraine, what used to be Poland, what used to be the Austro-Hungarian Empire, invented these legal terms in the summer of 1945. And Lauterpacht's view, he was the professor of international at Cambridge University, was that every living human being has basic minimum rights, and those rights are entitled to protection because that person is a living human being as an individual. And he was the one who took Crimes Against Humanity, which took forward his ideas on human rights, and were intended to protect the rights of individuals. And so Crimes Against Humanity is focused on the protection of individuals. Genocide, on the other hand, is about the protection of groups. And if I were to have an imaginary conversation with Lauterpacht and Lemkin, Lemkin would say, Lauterpacht's ideas are all well and good, but the reality is people are targeted and killed, not because they've done something, but because they happen to be a member of a hated group. And therefore, international law should protect human beings by reference to their membership of a group. So those two ideas operate hand in hand. Lauterpacht was opposed to the concept of genocide, as were others, as I write in the book, who wrote to Lemkin and said, your concept of genocide, biological in nature, is problematic. And Lauterpacht feared that genocide would replace the tyranny of the state with the tyranny of the group. Now, over time, it's been 70 years, 75 years since these concepts were invented. Over time, genocide has emerged as the crime of crimes. And I'm not sure why that is. There are different theories. There's plenty of evidence for that. If you speak to prosecutors at international courts and tribunals, they will tell you that victims want the crime that has been perpetrated against them to be the worst of the worst. And genocide is the one that is seen as the worst of the worst. So is it, on the one hand, possibly that the protection of groups is seen as more important? It might be that. Or my hunch that crimes against humanity is seen as a technical term, whereas the word genocide evokes horror on a different scale. I don't know. But in my own work, I've come to see how this hierarchy has caused a problem. And with so much focus on genocide, if an American president says a crime against humanity is being committed, no one pays any attention. But if an American president says a genocide is being committed, everyone pays a lot of attention. It's on the front page of the newspapers. And that makes crimes against humanity and war crimes seem somehow less bad. Frankly, I have a real problem with that. Why should the genocidal killing of 8,000 Bosnian Muslim men at Srebrenica be treated as worse than the killing of 3 million human beings in the Democratic Republic of Congo between 1998 and 2003, which is characterized as a crime against humanity or a war crime? So I do have a serious concern about this hierarchy that has been created. And we see that right now, for example, in discussions about the Uyghur community in China, another Muslim community, which is, we don't know the exact details of what's going on, but something obviously very bad is going on. It's not immediately apparent to me that what is going on is to be characterized as a genocide. I don't know whether China has an intention to destroy that group in whole or in part. On the basis of what's publicly available, we can't form a view on that. But very certainly, there appears to be ethnic cleansing, which is a crime against humanity, and other forms of negative treatment. And yet, certain governments, in part for political reasons, want to characterize what's happening as a genocide, and I think that's a problem. Coming to the second question, in 1948, as I mentioned, Lemkin succeeded in having adopted a convention on the prevention and punishment of genocide. There is no equivalent convention on crimes against humanity. Right now, the General Assembly of the United Nations is sitting on a draft convention prepared by the United Nations International Law Commission, largely by the Special Rapporteur, my very good friend and colleague, Sean Murphy, also another former student, who has done marvelous work. And my hunch is that if that convention were to be adopted, yes, indeed, crimes against humanity would be if you like, enhanced in the eyes of public opinion, and that would be a good thing. But plainly right now, we have a problem with the hierarchy that has been created.
Thank you very much, sir. We do have another question, and I also believe that this is quite a popular question. Would Bangladesh filing the case have made it materially different?
Sorry, can you ask that question again? Would
Bangladesh filing the case, as in had Bangladesh filed the case, could that make a material difference?
I mean, I think Bangladesh filing the case could have made, I mean, it would be a significant case. Plainly, Bangladesh is in a position where it is entitled to do that, and it's able to do that. It had its own reasons for not wanting to do that. But I don't think it would be materially a different case. And it might change the relationship between Bangladesh and Myanmar in terms of trying to sort out the issues of the refugees. So perhaps Bangladesh had an interest in having another state take the lead. But I think it's well known that Bangladesh has been supportive of Gambia's case and has provided various forms of assistance. I should say, as you know, there is another case that is underway, and that's before the International Criminal Court. And that is a completely different case. Myanmar is not a party to the statute of the International Criminal Court, and therefore there cannot be a case in relation to what's happened on the territory of Myanmar. But Bangladesh is a party to the statute of the International Criminal Court, and the prosecutor has opened an investigation on whether the treatment of the Rohingya community in Bangladesh, and in particular, their inability to return to their homes because of the actions of Myanmar, is a crime against humanity. That is being investigated right now, and the court has adopted a ruling saying that in principle, there may be jurisdiction for the International Criminal Court over that limited aspect of preventing the right to return.
Thank you very much, Professor Sands. We do have a question from Mr. Nafiz Ahmed. He is an alumnus of North University and is currently pursuing his LLM at Cambridge.
All right.
How may the current political unrest in Myanmar affect future proceedings? May there be reluctance to participate from the end of Myanmar?
Well, as you heard, I did address that in my words. I mean, it's a matter of speculation. I think you in Bangladesh are better placed than I am in London to know what the change of government will mean for Bangladesh. But I mean, we're all watching this space, so to speak. We are all thinking about this right now, and we are all trying to work out what it's going to mean. I don't know. I mean, it's a matter of speculation. The hope has to be that Myanmar will continue to participate in the case to defend its interests. But one thing that is very important to say is that if Myanmar decides no longer to participate in the case does not go away. The case will continue without the participation of Myanmar. That's not an ideal situation, but that is the practice of the International Court of Justice. I'm involved in one case right now in which that has happened. I'm counsel for Guyana in the case against Venezuela, and Venezuela has said it will not participate in the case, but the case continues. And of course, famously, in the case brought by Nicaragua against the United States participated in the jurisdiction phase. It lost. It failed to persuade the court that it should not exercise jurisdiction. The court rejected that, and the United States then walked away. But the case went on, and Nicaragua won the case. So Myanmar's participation obviously is significant, but it's not dispositive. And by walking away, they cannot stop the case proceeding. The case will proceed even if Myanmar does not participate.
Thank you very much. We do have another question. How to prove genocidal intent of Myanmar authorities?
Ah, yes. Well, how long have you got? How long is a piece of string? You know, the genocide that I wrote about in East-West Street was a very curious one in many ways. It was probably one of the few times in human history where the perpetrators of the genocide left a lot of evidence that they intended to destroy a group in whole or in part. This is unusual. Most mass murderers don't, as I mentioned, leave bits of paper hanging around saying we're killing these people in order to destroy the group, or we're raping these people in order to stop them having children so they can't continue to exist, or we're treating them in this way to destroy them in whole or in part. So you are left to infer that intention from a pattern of behavior. And as I said, inferring an intention to destroy in whole or in part is not an easy thing to do. And imagine, each of you, for a moment, that you are the judge, okay? And you are presented with the evidence concerning what happened to the Rohingya community in Myanmar in 2016, 2017. What would persuade you that the actions were intended, on the one hand, to destroy the group in whole or in part, or on the other hand, simply to chase them outside of Myanmar into the territory of Bangladesh? That is ethnic cleansing. And as things stand under international law, ethnic cleansing is not an act of genocide. It's a crime against humanity. And so one of the issues that will face the International Court is to form a view as to whether it is possible to infer from this pattern of behavior the crime of genocide. In that regard, the Gambia has been helped by the activities of the United Nations investigators, who have concluded, on the basis of intensive investigations, that they consider the crime of genocide is established on the basis of a pattern of behavior. But that's the essential challenge that is faced in a case like this.
Thank you very much, Professor Sands. We can only take one more question.
Okay.
We are running out of time. And the last question, do you see that in the coming years, there would be a distinct convention on the crimes against humanity?
There is a distinct convention on crimes against humanity. It has been drafted by the United Nations International Law Commission, and it's currently in the General Assembly, waiting for actions of states. I sincerely hope that states will push this convention, and it's a matter of very great regret for me, for example, the British government is not supporting the convention. And the reason that the British government is not supporting that convention is, I believe, in part because it is worried about a situation in which it is implicated for a crime against humanity. I want to end by mentioning a case to which I have a very great attachment and which anyone in Bangladesh would be very interested in. It's the case of Chagos. Chagos is an archipelago of 55 islands, which are located in the Indian Ocean, south between Mauritius and the Maldives. And I should say, I am the lead counsel for Mauritius in the case. In 1965, the United Kingdom detached Chagos from the territory of the colony of Mauritius, so that when Mauritius gained independence in 1968, it did so purportedly without Chagos being a part of it. For more than 50 years, Mauritius has wanted the Chagos archipelago back. And I and my colleagues, Paul Reichler, who's also acting on the Gambia case, have designed a strategy. And we've been successful in that strategy. In 2019, the International Court of Justice gave an advisory opinion which said that Chagos is part of Mauritius and the detachment was unlawful. And just 3 weeks ago, the International Tribunal for the Law of the Sea ruled that Mauritius has sovereignty over Chagos, not the United Kingdom. Now, related to this case, and it's one which people in Bangladesh will of course have an interest in, is the question of the right of return of the Chagassians. 2,000 members of the community of Chagos, the entire population, who were removed from the territory of Chagos between 1968 and 1973 to make way for a US military base at one of the islands called Diego Garcia. And you may ask, what has happened to those people? They want to go back. And despite the rulings of the International Court of Justice and the International Tribunal for the Law of the Sea, the United Kingdom is not allowing them to return. In my respectful submission, that is a crime against humanity within the meaning of Article 7 of the Statute of the International Criminal Court. It's exactly the same crime as the court is now investigating in relation to Myanmar's actions to prevent the Rohingya community from returning to their homes in the territory of Myanmar. And so the United Kingdom has a real problem in relation to the Chagassians and the possibility of a crime against humanity. And I'll end on not a very happy note, but you will also be aware that the United Kingdom has other colonies or former colonies. One of them is called the Falkland Islands or the Malvinas. And in 1982, as some of you will know, the United Kingdom sent a battalion, a naval battalion, to the Falkland Islands to remove Argentine forces. And it did so on the basis that the inhabitants of the Falkland Islands had a right to self-determination. And of course, the United Kingdom objects to the right of self-determination of the Mauritians in relation to Chagos. What is the difference? How do you explain this difference of approach between Chagos and the Falklands? It's very simple. I'm very sorry to say this. And you know all about this in Bangladesh. The community from the Chagos Islands is black. The Falkland Islanders are white. And if you want to understand the hypocrisy and the double standard of the British government's position, it's a matter of race. And that is what is going on. And that, I think, is why the United Kingdom is not supporting a convention against crimes against humanity, because it fears that it will be in the dock. So these issues are extremely important. I am personally very supportive of a convention against crimes against humanity.
Very strong words, Professor Sands.
Yep, I don't mince my words. If my own country misbehaves, I'm going to say that loud and clear.
Professor Sands, thank you very much. It was an absolute honor on the part of North-South University to have been able to get you, to have been able to hear you. And I am quite sure all of our participants enjoyed your lecture or your talk thoroughly. We do look forward to inviting you even more. And if there's anything that you'd want to say towards the audience, please.
Yes, no, I just want to thank you for the invitation. I would like to send you a couple of copies of East West Street for your library. So if you or Professor Islam give me a mailing address, I will send a package. And the sequel to it has just come out, which was just published now, just a few weeks ago, The Rat Line, which is Hans Frank's Deputy. It's a trilogy, and the third one will concern the famous case of Pinochet, and that will come out in 2024. And I will be pleased to send that to you. I'll send you all of these. But in the meantime, in 2022, I am publishing another shorter book on decolonization and international law, the Chagos story. And I just want to finish by wishing everyone well. These are enormously difficult times. with the pandemic and with COVID-19. And I know that, like every other country, my countries, France and the United Kingdom, Bangladesh has been deeply hit by this. And I know particularly for the students among you, this is a very, very difficult time. And I just want to say that for my generation, we know that, we understand that, we want to do everything we can to make your studying more interesting and more exciting. That's one of the reasons I wanted to agree to do this event, as part of trying to make you feel we're all in this together. There is a global solidarity on this issue, and I want you to be well, and I hope you are safe, and please take great care. This is a very, very nasty virus.
Thank you very much, Professor Sands. For everybody, I should mention that this video will be uploaded in our YouTube channel, provided that you want to hear it once again. Professor Sands, thank you very much. Good night,
Okay, thank
everybody.
you.
Thank you.
Bye-bye.